Former White House Chief of Staff H.R. Haldeman found guilty today on 5 counts in the Watergate cover-up trial. Former White House Domestic Affairs Advisor John Ehrlichman, 4 counts, guilty. John Mitchell, former Attorney General and head of the Nixon Re-Election Committee, 5 counts, guilty. Robert Mardian, former political coordinator for the Re-Election Committee, 1 count, guilty. Kenneth Parkinson, lawyer for the Re-Election Committee, 2 counts, the only defendant found not guilty.
This is a special report from CBS News in Washington, the Watergate verdicts. Now here is CBS News correspondent Barry Serafin.
Good evening. Some of the defendants in the Watergate cover-up trial left the federal courthouse here in Washington last night expressing wishes for a happy new year. But most of them were not surprised when their own new year began today with the jury finding all but one of them guilty. The verdict came 2.5 years after the Watergate break-in and 13.5 weeks after the trial began. In those weeks, more than 12,000 pages of transcript were accumulated as more than 80 witnesses appeared, and 34 of those famous White House tapes were played. CBS News correspondents Fred Graham and Jed Duvall were at the trial from its beginning October 1st until its end late today. Fred, first, what about the case against H.R. Haldeman?
Well, the case against Haldeman was the strongest of all because as Richard Nixon's right-hand man, he was the one most often recorded on the tapes, and they destroyed him. The most damaging was the conversation with Mr. Nixon on June 23rd, 1972, in which they agreed to use the CIA to block the FBI's investigation of Watergate. It was enough to force Richard Nixon from the presidency, but Haldeman told the jury they didn't do it to cover up Watergate, but just to avoid political embarrassment. Haldeman also turned over a secret $350,000 White House cash fund that was paid to the burglars. He said he didn't know it was to be used as hush money, but again, the tapes made it clear that Haldeman knew. Finally, the jury found that Haldeman lied under oath when he took the stand before the Senate Watergate Committee to defend Richard Nixon against the allegations of John Dean. Haldeman insisted that he's innocent.
I'd just like to make a very brief statement, simply to say that there's only one human being in the world who knows to an absolute moral certainty the truth of my innocence or guilt. I know that legally and morally, I am totally innocent of each of the charges that's been brought here. And with that certainty, I can live with myself, and I can move ahead now to see that as this process continues, the truth ultimately does become known and become understood. I have the full conviction that ultimately it will, and with that, I intend to move ahead in the days ahead on the process of appeal within the judicial system. Thank you very much.
The testimony of John Dean and Herbert Kalmbach hooked John Ehrlichman to that money that was given to the burglars and their attorneys. It was Dean who told the jury that Ehrlichman told him to deep-six some of the evidence. On the witness stand, Ehrlichman tried to explain himself out of the CIA involvement by saying that all he did in the key meeting was say to one of the intelligence officials, "Here, you can use the phone." Back in May of 1973, nearly a year after the break-in, Ehrlichman sat before a grand jury and was asked if he had known of Gordon Liddy's involvement in Watergate. His answer was, "I don't recall," several times. More lack of recall when asked about Herbert Kalmbach and that hush money, and the jury decided that his statements were false and he knew it. And after the verdict, he said, "It does not change my deep-seated feeling of innocence."
When you weigh it against the harm done in the whole process, I suspect that history may strike a different balance than some of the instant commentators are striking right now.
Mr. Ehrlichman, are you saying that too much has been made of Watergate, really?
Well, I'm saying that it is possible to make too much of it, and somehow or another, I think someone who stands a little farther away from these events is going to have to take a long view and make that balance. Obviously, neither you nor I can. I suspect that not even Eric Severide could.
The charge against John Mitchell was that he approved the Watergate break-in and then joined the conspiracy to cover up his guilt. He was pictured as the big enchilada who manipulated the cover-up from the background, holding meetings at his apartment to plan cover-up strategy, suggesting that Jeb Magruder have a fire in the summer and drop some evidence in it, arranging to have others make hush money payments and lying to the grand jury. Mitchell said it just wasn't true, that he had nothing to do with the break-in and thus had no motive to cover it up. Sure, he concealed facts about Watergate, he said, but he did it to protect the president's re-election, not to obstruct justice. Mitchell was the trial's mystery man, puffing his pipe, cracking occasional jokes, refusing to attack Richard Nixon, even after the tapes proved that Mr. Nixon had betrayed him, and saying little else. Tonight, after the verdict, his style hadn't changed much. When asked if he was going to appeal, his answer was, "You'd better believe it."
It may be the evidence that hurt Robert Mardian, evidence of a telephone call placed to Gordon Liddy's number only hours after the Watergate arrests. Or it may be Mardian on the stand that hurt Mardian's case, snapping and snarling so much at the government's Jill Wine-Vollner that Mardian's attorney, Tom Green, apologized for it in his closing argument to the jury. Is that relevant? Mardian once shot at Ms. Vollner. Another time, "What do you want me to say? Yes, yes?" It was Mardian who claimed that the real day-to-day director of the committee to re-elect was then President Nixon himself. He discovered this, said Mardian, only when he found the decisions of his friend and mentor, John Mitchell, being overruled, and figured there was only one power that could accomplish that. Mardian discussed commitments to the Watergate burglars the government charged, commitments the jury evidently considers to mean promises to buy silence from those who broke in and were arrested. Mardian was there in John Mitchell's Washington apartment on the evening of June 19th, 2.5 years ago, when Mitchell talked to Magruder about that fire at his home. Magruder did it. Mardian had heard it. And it was Mardian who this evening, dogged by a reporter to his hotel room, burst out in fury, used language unheard even on the tapes, and was calmed by John Mitchell.
There was a gasp of appreciation in the courtroom today when they announced the acquittal of Kenneth Parkinson. He had presented himself as the Mr. Clean of this case, the politically naive lawyer and doer of good civic works who was hired as respectable window dressing by the Nixon men who didn't tell him they were involving him in obstruction of justice. Parkinson's lawyer, Jacob Stein, stressed that Parkinson was an outsider, so different from the politicians that Stein said he was probably helping crippled children at the moment the Nixon men were planning to hire call girls to subvert the Democrats. Parkinson had his credibility problems. He told the jury he didn't read a list of money demands from the burglars that he Xeroxed and passed along to the White House. But in the end, even if the jury didn't fully believe him, they apparently felt he was a victim, not a participant in the cover-up. Afterward, he and his lawyer played it calm and cautious.
I said then that I was innocent and that my friends could count on. There would come a time when I would be able to clear myself, and that time's come today.
Do you think those prosecutors were too aggressive in this case?
Now, Fred, you're being too aggressive.
Could you answer that? Would you answer that? Would you answer that?
We wouldn't want to comment on that.
What are you going to do now?
Go home, take a hot bath.
The prosecution team was headed by James Neal of Tennessee, best known before Watergate for his prosecution of Teamsters President James Hoffa. Neal, who had dramatically argued in the courtroom that the cover-up defendants had defiled this country's highest offices, was subdued today when asked if he now felt satisfied.
I don't think satisfied is the word. It's one of relief that a long and hard job is over, and I can go home.
How do you feel about the verdict?
Well, you know, you practice law for long enough. You just let the juries decide, and you live with them.
Were you surprised?
Whether they accept your theory or not.
Came nearly 5 months after the cover-up scandal forced Richard Nixon to resign as president to be succeeded by Gerald Ford. Mr. Ford was still vacationing in Colorado when the jury's decision came in. Phil Jones reports.
President Ford was watching the Rose Bowl football game today when the verdict bulletin came in. After discussions with some of his advisors, the president decided not to make any public comment on the verdict because, in his news secretary's words, the president doesn't have anything to say about it. However, one of Mr. Ford's closest advisors has told CBS News that today's verdict appears to be a careful one, and that even though one hates to cheer about anybody's misfortune, this was a wholesome verdict for good government. The same aide, who was asked not to be identified, says there is no chance that the convicted Watergate defendants will receive a presidential pardon. The Ford administration does not expect this verdict to provoke more criticism of the Nixon pardon, and in the view of this one aide, today's verdict proves that the truth could still be ascertained after the Nixon pardon. And the aide continued, today's verdict establishes that former President Richard Nixon was involved in the cover-up conspiracy and that Mr. Nixon was also guilty of criminal conduct. Phil Jones, CBS News, with the presidential party in Colorado.
Today's verdict does not mean the end of the legal line for the 4 convicted cover-up defendants. John Ehrlichman said the legal process is a journey of 1,000 miles. He and the others plan to appeal their convictions. More on that from Fred Graham.
The final irony of Watergate could be the difficulty that these convicted men may have with their appeals because of the 4 law and order justices that President Nixon and John Mitchell put on the Supreme Court. These justices succeeded in writing into the law a new concept of harmless error. That is, the rule that even if the defendant's constitutional rights have been violated, his conviction won't be overturned if it appears that he was so guilty that the jury would have convicted him even without the error. Defense lawyers concede that this new law and order mood hurts their chances of success. Before the verdict today, Judge Sirica agreed to have his picture taken with the reporters who covered the case, and it was a mild example of the kind of unusual judicial behavior that created some talk early in the case that he might have committed reversible errors. But then things settled down, and lawyers on both sides said he had run a fair trial with no obvious reversible errors. Therefore, the defense lawyers intend to focus their appeals on decisions Sirica made before the trial began. One point they'll stress is that prejudicial publicity so soon after the Nixon resignation and pardon made a fair trial in Washington impossible.
Long ago, as last March, when this indictment was delivered, we began to express our very strong and sincere concern about anyone's ability to get a fair trial under the circumstances in this district. And by fair trial, I mean in the political setting and with the massive pretrial publicity, the pervasive publicity. And I think when the record of the jury selection process is finally released, you'll see how terrifically pervasive all this political publicity and the impeachment publicity and so on has been.
Another point is that Judge Sirica insisted on trying this case himself, even though it was he who has said all along that the involvement of higher-ups in Watergate was being covered up. Defendant Robert Mardian will appeal on the ground that he shouldn't have been tried with the 3 major defendants and that the jury simply convicted him along with the big 3. But the point that the defendants think is their strongest point is Judge Sirica's refusal to delay the trial until former President Nixon was well enough to testify.
I felt strongly, and my attorneys advised me very plainly, that Mr. Nixon's testimony was absolutely essential to the establishment of our defense. When the judge ruled that we couldn't wait 5 more days to take his deposition, that was, for my money at least, the major turning point in whether or not this verdict was going to be a statement about my innocence or was simply going to be a statement about the evidence that was presented in the courtroom.